Apple store in Manhattan. That was the first design patent which was given for the architecture actually. So that is when people came to know that they can actually patent a architectural site. Okay, but in India actually to tell the truth, only in the last 5 years people are actually getting to know about these patents. So the general crowd, not the creamy layer. I remember my own professor saying like his PhD work was commercialized somewhere else. So he was feeling very bad that I could have patented it that time, then I would have earned so much. So they didn't know about it. In fact, he was from IIT only, but they did not know about this patent. So now only India is getting to know about all these patents. We still have time to go to that level actually. So I am Dr. Vidya. Now actually I am a PhD in mechanical engineering. Nana University la PhD panenen nana. So now I am also working as a professor in a private engineering college, and I also have my own consultancy service. And apart from that, we also do patents filing for many inventions. So we help them to prepare the legal documents. So adellam pannittu we help them file the design patents as well as the utility patents. So idellame we do through our consultancy service. So apart from this, I also conduct certain training programs for corporates and students also in my area of mechanical engineering. So patent is actually an intellectual property right. So intellectual property right na enna like some ideas or what we think, that is our individual property. So everybody is not going to think the same way like how the other one thinks. So நம்மளோட own thinking process வந்து நம்ம safeguard பண்ணிக்கிறது தான் வந்து we are doing it through a process called patent. So இந்த patent வந்து எதுக்கு நமக்கு applicable இருக்கும்னா, like for example you are inventing something new. Okay, so it could be in any field. So in case of architecture la வந்து your design is unique and new. Okay, so in case of mechanical engineering, new machines will be invented. So idellame it is only based on the thinking of that particular individual. So when this particular individual gives out these ideas, so he is going to fabricate or build that particular structure. So it is going to come to the knowledge of the world. So adha vandu vera yarum vandu misuse panni adaitu they shouldn't gain monetary benefit or any other benefit. So it actually belongs to that particular individual who has actually thought about it. So we are going to protect that idea or protect that particular project by using these patents. So that is what is called as patent. So patent, intellectual property right அப்படின்றப்போ there are many kinds of intellectual property rights. So first one is patent. So patent வந்து it covers both the functional aspect as well as the appearance of the particular product. Okay, so on the functional aspect indrappo like everything will be varying in the function. In case of architecture, there are many buildings which have functional aspects. For example, green buildings. There are many new approaches which are coming in architecture nowadays. So all these are functional aspects of that particular building. So these things can be covered, and not only that, even the aesthetic appearances are being different in every building. Okay, so for example, like Apple store in Manhattan, that was the first design patent which was given for the architecture actually. So that is when people came to know that they can actually patent a architectural site. Okay, so and the mari like that design, but now that particular design of that store cannot be copied anywhere else. Okay, so that is the main protection we get. So your product will be unique, and your product will be validated that it is unique by using this patent. So second thing is idu vandu utility patent, and next one is design. It is called as industrial design, and in US it is called as design patent. In India la vandu it is called as industrial design. So in the industrial design la what is being covered is not the functional part of the product. It covers the aesthetic look of the product. Okay, so for example, I am having a cell phone, that how I have designed that particular cell phone, where that camera hole is coming, all these things can be taken care in that design patent. So similarly in architecture, your design plan, the entire plan of the structure, all these things can be safeguarded by using a design patent or industrial design. So similarly we have other intellectual properties also, like copyrights, trademarks. So copyrights are mainly for literary works and such kind of, even for architecture also we have copyrights. And then we have trademarks. Trademarks are like the company symbols. So each and every company has a particular symbol, so that can be trademarked. And then we have geographical indications. So for example, if a particular product is available in only that particular country or a place, for example Tirupati Laddu, that is being given a geographical indication because it can be, that special sweet can be obtained only in that particular place. So that is given that particular, for example Kanjipuram silk, all these are geographical indications. So like this we can classify the intellectual property rights. So we will be able to safeguard our ideas using this patents and all these kind of intellectual property rights. So patent can be applied by anybody, even children. Okay, so actually now even government of India, they are conducting contests for children for various scientific small ideas, like they have this called innovative ideas award, APJ Abdul Kalam award for children. Actually what children do is they will not go too much into technical part of it, but they will give us very innovative ideas. For example, one child she told that if there will be a watch, if I press the watch, whenever I am in danger, if I press the watch, chili powder is going to come and fall on the opposite person's face. So that is the level of thinking of the child, but still those ideas also can be developed and it can be patented in that child's name. So there is no qualification for applying a patent. Even a child can apply a patent. So nowadays, like who is applying for patent is like anybody, any professional companies. Okay, so software company or any other company, if they have designed and developed a particular product, so they can apply a patent for that particular product so that nobody else will mimic that product. So anybody can apply the patent. So when you file a patent, your idea is being protected from the date of your application. So when you are filing, so from that date, because we are not going to wait for only the grant may take few years for the entire process of examination. So from the date of filing, nobody can use your idea and mimic that idea is somewhere else. So this is the main thing. In case somebody is going to copy your idea and he is going to commercialize that, then we have all the rights to file a case against them for the infringement of our idea. So that is the main protection you get for your ideas. No, it all depends on who files first only. So even if it is one day before, the person who has thought one day before will get the credit. So that is how it. Yeah, but a certain patent, for example, if in India we are going to consider the worldwide full patents. Okay, so anybody who has patented outside India also, it cannot be repatented over here in India. Whereas US patent law is different. They consider only the patents inside US. If it is patented elsewhere in the world, they don't bother about that. That is why, like for example, all these turmeric kind of medicines and all, they are all our traditional origin. But those products are being patented in US. We cannot patent it because it will come that it is having a traditional originality. We cannot patent that particular product. So it will come like that. But US can patent it because they are considering only the patents inside their own country. So, but India, we are going to do the entire world, wherever it is being patent is applied, we take it into consideration and we cannot repatent it over here. So for that, what we do is we will be doing a patent search. So that patent search will tell us what are the different patents which has been applied throughout the world, and we have to check whether our idea is similar to what what has already been filed. So when we check that, we have to show the differences. Maybe like if there are huge differences, definitely it can be patented. It is not necessary that it should be completely different. There could be few aspects which could be different. For example, in architecture, like not the entire building, but certain features like the fountains or the place where we have kept the windows, all these minute details also can be different and it can be patented. So using the design patent. So like that we will be able to do the variations. Even though we have similar patents filed before, we have to show the difference so that we have to show that our idea is unique and novel. That is the main thing. See, as economic generation, it depends on how you are going to commercialize your product. So for example, if it's going to be a machine, okay, so if it is going to be a machine, you are going to design and develop a particular machine and you are filing a patent for it. So that machine can be used for many applications. So that patent, whoever is going to commercialize that product in a manufacturing sector, they have to file a license with you. Okay, so they have to get a license from you that they will be able to use your inventory idea for their commercial and monetary purpose. So that is how they will be able to commercialize it. So in that case, the patentee also will be getting a royalty, so based on how it is being commercialized. So this can be applied in any field. It could be a medicine, it could be architecture also. So architecture, that particular feature, nobody else can use it. If you want to use it, you have to get the permission from the patentee, and then only you can use it. But when you are getting the permission from the patentee, there will be an agreement saying that this will be the royalty which will be given to you. So such kind of monetary benefits the patentee will be able to get. So once we have actually, patent can be filed in two different phases. Okay, one stage is when we have the idea itself, or you have not completed the work yet, but still your idea is in the halfway through, but you are still afraid that somebody else, as you said, somebody else may file a patent before us. So if we want to get that priority date, there is something called as provisional patent. So provisional specification. So in that, what we do is we will only give the abstract and the claims, okay, so, and we will file that patent. So we will be protected from that date itself. Once we file the provisional specification, we have 12 months time. So within the 12 months time, you have to complete your project, and then you have to file the complete specification. That is the main patent application. So once you file that complete specification, then it will be going to the patent office, and they will do an examination. So the patent examiner over there, he will do a complete patent search. He will see what are the similar patents available for that. If he finds that our patent is similar to something which has already been filed, then he will say they will send us a first examination report. So that first examination report will tell us that these are the patents which look similar to what you have sent us. So that is what they. So we have to write a reply to them how our patent or our product is different from those patents. So we have to justify that ours is unique and novel. So there are only three major criteria for getting a patent. One is it must be novel. The second one is it must have an inventive step. Third one is it must have an industrial application. So these are the three main points which is considered to get a patent. So they will see all these 3 points. We have to convince them with our reply. So if the examiner is convinced directly, then he will grant the patent directly. Otherwise, they may call us for a hearing. So they will call us directly, and they will ask us for oral examination. Sometimes they will ask us to display the product also. So once they are convinced that it is unique and it is having the novelty, inventive step and the industrial application, they will grant the patent. So one of my patent was MicroGripper. Okay, so MicroGripper is nothing but it can hold micro components of size ranging from 1 micron to 999 microns. So we had designed and fabricated 5 different sized MicroGrippers for 3 different shapes, for handling cylindrical objects, for handling square prismatic objects, and for handling sheet metal kind of thin rectangular prismatic objects. So these were the MicroGrippers which we had designed and fabricated also. We actually fabricated it using additive manufacturing method, which is first of its kind for MicroGripper. So once we had completed the entire design and fabrication of the work, what we did was we filed the complete specification. We did not go for the provisional specification, we filed the complete specification. So this was actually filed between Baba Atomic Research Center and Anna University, because I was a research scholar at that time. So it was filed by these two, and we were the inventors. So the Baba Atomic Research Center scientists, as well as my own professors and myself, we were all the inventors. So we filed this particular application in 2016. Okay, so once we had filed it, we had various forms to be filled. It gives the inventor details, then it gives the complete, we have to, form 2 is the complete specification, and then we have to give examination request. Okay, and there is something called early bird publication. All the patents whichever is filed, it will be published in a patent journal. So generally, if we don't give early bird publication, it usually gets published within 180 days from the date of filing. So if you want your publication to come early, we have an early bird publication. For that we have to give a particular form. So all these forms will be drafted and it will be submitted to the patent office. So once it is being submitted, then there will be a queue actually, like it comes only from the date of filing. So there will be so many people who have already filed before me, so they will go according to that queue, and then it will be going to a examiner. So that examiner, he will, as I told you, he will examine the entire patent, and he sent us a FER. It was almost, it took us 3 years for us to get the FER. So once we got the FER, they cited a few patents which was similar to this. So then we actually framed a reply stating that our patent is different from what is already existing, and we showed them what are the differences which is available. And while filing itself, we also told them the industrial application where it can be applied. But not much statistics over here, because India la portha varaikkum patent endradhu ippada it is actually upcoming. There are so many products in the past which we have not patented. If we would have patented all our turmeric and all our medical products, nobody can use it actually. So there are so we cannot say that there is a huge income because of the patent, but however these companies, like they file it in their name, no? For example, the software company or some very unique algorithms are actually not patentable in India, but they are patentable in US. So these kind of patents and all, they will sell it to that particular another company. So when they are going to sell it to the another company, either it can be sold as a single thing, or as I told you, it can be done as a royalty based on how much profit they are giving. So it varies. So only if we commercialize the patent, it will be useful for us in monetary benefit. Otherwise you can only preserve your idea. So there is no much statistical data in case of India, because it has various ranges. Like a small product may have a patent at a very small level. When the product is very huge and expensive, then it may have a different level. Same time, the applicability. Like for example, if it is going to be having the application in a small circle, then the monetary benefit may not be very high. But if it is going to be in a large circle, like anybody, for example, this diabetes testing kit. So that would have been patented before, I guess. But sometimes what government do is, somebody who is going to patent that particular kind of products which is going to be very useful to the human beings, they provide compulsory license. Even though the patentee doesn't want to apply for any, give license to it, the government will come in between and they will ask them to give compulsory patent, because it is it's having a very good use to the humanity. So they will ask them to do it compulsorily. So such kind of patents licenses will be given. The companies, for example, a medicine has been invented for a very dangerous disease, and that particular inventor, he is not ready to give it out, but government will come in between. You have to give it, like they will ask them to give compulsory license, and he will also be benefited with that, but government will compel him to give that license to that particular company. So all these kind of things will be there, but we cannot say this is the income, this is they earn, like that we cannot. That's what US has very well developed with this, because they have been patenting it for a very long time, all the ideas and everything. So now they are coming into the commercial market of patents. But in India, actually, to tell the truth, only in the last 5 years people are actually getting to know about these patents. The general crowd, not the creamy layer, the general crowd or the research scholars, even the students, why even the professors who are in the line, only in the last 5 years or 10 years only, they are actually knowing about this patenting and all these things. So I remember my own professor saying, like his PhD work was commercialized somewhere else. So he was feeling very bad that I could have patented it that time, then I would have earned so much. So they didn't know about it. In fact, he was from IIT only, but they did not know about this patent. So now only India is getting to know about all these patents. So we still have time to go to that level actually, to tell the truth. We still have time. So now next thing is, there is not much awareness, even though the patent is being granted or patent is being filed, there is not much awareness how to commercialize it, where to go and approach, who will be able to use our product. All these hindrances are still there over here. Still there is not much awareness about all these things in India. So that is why there is not much earning with the patent in India. But still the companies, they are earning well. As you told, in US and all, like the patents will be, because they always look into that patents itself, like these companies will be searching for the patents, who has got that patent. If it's going to be really useful for the company, they themselves will approach the individual and they will do it. But India has not gone into that level yet. That is even the companies, some people, they are not aware of the patents. So that when that awareness comes, maybe in another 5 years, I think we will also be into that level. Only if you file a patent, you will be able to safeguard your product. If you have not filed a patent, if somebody else copies it, we don't have any proof that it is ours. He has patented it. If you have the research paper, then actually he couldn't have got the patent at all. Actually, before filing a patent, so actually it shouldn't have been published. This is the normal law. Even if it is published by mistake, it has been published, within 1 year of the publication in a journal, you have to file the patent. This is the norms followed in Indian patent. So if you have published something else, definitely in their patent examination, they would have got your document. So then they wouldn't have given a patent to him at all. Actually, in case of patent search, it is not involving only the patents. It also involves the research articles also. So if it is previously published research article, they cannot patent it again. So if you have published the research, if he has obtained the patent, definitely he has shown that something is novel and different from what you have already published. So in that case, you cannot fight with him, because he has already proved that there is something different. So that's what, like only if we file the patent, we will be protected. That is the main thing actually. If you have not filed the patent and you are letting out your ideas at free of cost to the public, it can be stolen anytime. So this happens not only in the technical field, even in the arts field also it happens. Like we hear many stories, no, my story has been taken as a cinema now. So all these kind of copyright issues also come, but still they cannot fight against. They can only orally fight against it, but they don't have solid ground to say that it is their own idea, unless they file an intellectual property right. It could be a patent, it could be a design, it could be a copyright, whatever it is. Unless they file an intellectual property right, they cannot claim that it is their own thing. So architects generally like they have many unique ideas. They are coming up with new designs, new buildings, and as I told you, the buildings are having both functional aspects as well as aesthetic aspects. So definitely, to validate your work, you have to show that it is unique, and you don't want anybody else to copy the same work. So for example, even the artworks, like a Mona Lisa painting, it was the first thing. It was not patented. So that is why now also we are seeing mimics of such Mona Lisa arts, selling it. Even anybody can actually just take a picture of it, they can frame it and they can sell it. Okay, so such kind of things were happening before. So now you want your particular building structure to be unique and be validated that it is your own idea. You have to patent it. So you will be able to market it even in a better way that nobody else will. Now you have designed something, it is not been constructed yet, but you have designed a particular architecture. So you can, when you are going to show it to your client, so you can say that this is a very unique idea, nobody else will do it anywhere else. So you can take my idea and you can construct that particular thing. So that is a kind of monetary benefit you will be getting. So all these are some of the uses that you will be getting by filing a patent. Sure. As I told you, there is something called design patent also. So in India it is called as industrial design, and in US it is called as design patent. So those are only the aesthetic appearance of the particular product. Okay, so your architecture, your design plan, okay, the way of aesthetic appearance of the building, all these can be patented. So for that, what we do is we file separate application for the industrial design. So in that, we only give the drawings or the photographs of the product what you have made. So those things will be sent to them. So that also, similar to patent search, they will also do a design search. They will see whether this particular design has been previously done or not. If they find that it has not been done, then they will be granting you a design. So that the design patent processing period is short. within 6 months itself you will be able to get a design patent. Whereas a utility patent, which includes the functional aspects and all these things, it may take years. It depends on the field. If it is a new field where not much inventions have happened, you may get it very easily. But if it is an old field like a mechanical engineering or such kind, or like where you have large amount of patents already been filed in that particular field, then it may take some time. So that may take even 5 years or 8 years also, sometimes it takes. Some patents are granted even within a year also. So it depends on the field of application. So design, architects can file their designs, the drawings, whatever they have done, everything can be filed as a design.
Architecture patents products.
So architecture two types of patents, that is, one is utility patent, second one is design patent. So in case of utility patent, they actually preserve the functional aspects of the building. Okay, for example, already what they have filed is, as I told you, the Apple store in New York, they have done that. And then there is a patent where they have inclined structure of the building, story by story, that kind of thing, and well shaped structure, and these kind of structures have been patented previously. And not only these, even the small functional aspects alone, for example, like if it is going to be if it is going to be having some energy harvester inside, okay, at that particular building, or if it is going to have some cooling effect, or you have so many functional aspects in architecture, right? Like the cooling comes or naturally itself without having an artificial cooling system like an air conditioner or anything. And green buildings, as we told, like it is going to consume the energy, that renewable source of energy, so that it can be used for the power system of the architecture. So all these things have been patented previously also, but different kinds of buildings, different kinds of things have been patented. So in case of design patent, they actually file the aesthetic appearance, as I told you. So that also the place where they have placed the curtains and where fountains, different kinds of fountains in that particular building, all these things also have been patented.
Can we call design an intellectual property?
Yes, design is an intellectual property, because you are going to use your intellect and design that particular thing. It is only your mind which is actually thinking about that particular. It's similar to a drawing. If you are going to draw a cartoon character, it is your imagination. So similarly, you are going to draw a building structure. So it is your imagination and your thought process. So definitely it is an intellectual property. So that is why the government itself is allowing us to file the design patent.
License a patent.
So license a patent na like when you file the patent, so you are actually safeguarding your idea. So nobody else can use your idea. But at the same time, your idea has to be used by others so that others will get benefited. Okay. So in that case, what they do is they will give license of that patent to somebody else, so that they will commercialize it and use it to the society. So they will be signing an agreement between the patentee and the licensee. Okay, so this license also can be of different types. It can be an exclusive license. So in a case of exclusive license, there will be only one licensee, and you give him all the rights to the licensee. So whoever is infringing that particular patent, he himself, the licensee itself, will be able to take action. He need not have any permission from the patentee. So if it is going to be a non-exclusive license, there may be more than one licensees, and they should also get the permission of the patent to file a case against some infringement. So and sole license is there, and as I told you, compulsory license is also there, where government will come in between and ask the patentee to give compulsory license. So all these kind of licenses is mainly done to commercialize that particular product so that it can be useful to the society.
Okay. What are the conditions to get a patent?
So to get a patent, there are three main conditions. Okay. So first one is it should have novelty. Second one is inventive step, and third one is it must have an industrial application. So these are the three main things to get a patent. So if you prove that there is something novel in your design or in your architecture, definitely that will be all these, like when in your examination report, you will be seeing all these points when you receive that first examination report. the examiner would have told whether it is novel, they will be asking, and the examiner would have told, he would have searched the patent and he will give yes it is novel, or if it is not novel, he will say what are the different patents which is having similarity. Similarly, next one is the inventive step. So how unique or your product is, how it is being invented, like it's not a like it should not be similar to already existing ones. So that is called inventive step. And third one is industrial application. Without any applicability, there is no use of filing a patent also. Okay, so if it's just going to be a stone, there's no nothing going to be filed for that. So there must be some industrial application so that it will be useful to the society. So these three things will be taken into consideration, and then they will do a complete research on these three things on your particular product, and then they will grant you the patent.
Is there anything called as international or worldwide patent? இப்போ நம்ம இங்க வாங்கினா நம்ம world full-ஆ
yeah, so அது மாதிரி வந்து it's not a worldwide patent. Actually there is something called patent cooperation treaty. Okay, so that is a treaty or an agreement which has been signed by 156 countries. So those 156 countries can be covered using a single application. So actually by process, if I want to patent in India, I have to file a separate application. If I want a patent in US, I have to file a separate application. Similarly for each and every country, I have to file a separate. So it is going to be a very tedious process for each, because there are so many countries throughout the world. So they have come into this is called PCT, that is Patent Cooperation Treaty. So when you file an application using this PCT, you can cover all that 156 countries, or you can also select these are the countries in that 156 countries. I want to cover these countries. So like that we can file it. So once you file that particular application, it will be processed by WIPO. It's like a patent office, worldwide patent office. So they will be processing this application. So they then once the patent is granted, whichever countries you have specified in that particular application, in all those countries your product will be patented. So in that maximum up to because 156 countries have signed that treaty, up to 156 countries we can cover that patent.
So actually முன்னாடி நீங்க சொன்ன மாதிரி இந்தியால மட்டும்ங்கிறதுக்கு ஒரு ப்ரொசீஜர் இருந்தது, லைக் இட் வில் கோ there will be an examination, நேர்ல போய் சொல்லணும் மாதிரி. இது 156 கண்ட்ரீஸ்லயே அதை செக் பண்ணுவாங்க.
இல்லை, இது வந்து 156 கண்ட்ரீஸ்லையும் செக் பண்ண மாட்டாங்க. அந்த விப்போன்னு ஒரு ஆஃபீஸ் இருக்குது ஆக்சுவலி. ஸோ தட் இஸ் ஆக்சுவலி லைக் அதுதான் வந்து திஸ் பிசிடி அப்ளிகேஷன்ஸை டீல் பண்ணுறது. தே வில் செக் வேர்ல்ட் வைட் யோர் அப்ளிகேஷன். ஒன்லி சிங்கிள் ப்ராசஸ் தான் உங்கள் அப்ளிகேஷன். எப்படி இப்போ இந்தியன் பேட்டன்ட் நம்ம ஃபைல் பண்ணால் இங்கே என்ன ப்ராசஸ் நடக்குதோ அதே மாதிரி சிங்கிள் ப்ராசஸ் தான். பட் இன் அ சிங்கிள் ப்ராசஸ் யூ வில் பி ஏபிள் டு கவர் மெனி நேஷன்ஸ். தட் இஸ் தி அட்வான்டேஜ். ஒவ்வொரு நேஷனுக்கும் தனித்தனியாக ப்ராசஸிங் ஃபீ, தனித்தனியாக அப்ளிகேஷன், தனித்தனி ப்ராசஸ் இல்லாமல் ஒரே அப்ளிகேஷனில் நிறைய கண்ட்ரீஸை வந்து நீங்கள் கவர் பண்ணிடலாம் நீங்கள்.
ஸோ லைக் ஆர்கிடெக்சர் அண்ட் காப்பிரைட்ஸ் லா, அது வந்து ஆர்கிடெக்ட்ஸ்க்கு எப்படி யூஸ்ஃபுல்லாக இருக்கும், இல்லை why everybody should know about it?
So actually like there can be a question like why I should patent it. I can do a copyright itself. Copyright is also an intellectual property. So actually there is a difference between this patent and a copyright. So design patent and a copyright. Okay, so both are actually going to have your designs or whatever drawing you have given. So it can be copyrighted also, it can be design patent also. But in case of copyright, for an infringement they need two things. One is they should have copied your design, and they should also have access to your design. So both these points, if we are able to prove only, then only it will be an infringement in copyright. Whereas in case of design, only if it is a mere copying of your design itself is an infringement. They need not have any access to your design. For example, there is a particular building, it is completely secured, and you have done some unique interior over there. Okay, so you have given like for example like you have given glass curtains and at that particular place, and your finishing is in the marble, and all these kind of things are over there. So a copyright can have similar building, which instead of glass curtain, the same design he can give a metal curtain. Okay, so instead of marble he could have used a granite. He can show such kind of differences, and he can say that it is different. So this is not an infringement in case of copyright. Whereas in case of design, it is an infringement. So your design will protect your idea or protect your structure, I mean design, in a better way than copywriting it. So any architecture, why he should copyright it or why he should patent it is because everyone is going to give a unique idea. So, as I told you, it is also going to deal with the functional aspects. So copyright is not going to deal with the functional aspects. There are so many things. If it is just a mere design, even a school student can, like instead of putting a triangular roof, he can put elliptical loop or something like that. He can say that this is my new design. So it's not like that. There are so many functional aspects also involved in the architecture. So those functional aspects also can be brought into this design, and you will be able to validate yourself in a better way when you actually file a patent. So you can show it to your clients that your designs are unique. So in the field of architecture, the more unique designs you create, the more competitive you are. Instead of having the same routine designs of the buildings, if your design is really unique, at the same time it must be stable, at the same time it must be functionally good. So all these things are taken by care of an architecture. So when you file all the patents, you are proving yourself indirectly that your work is unique. So you will be able to show and showcase your work in a better way. So you can file a patent for that.